This is Barry Zalma speaking for Claim School Incorporated and Zalma on Insurance. This digest of an appellate case deals with how a videotape proves an excluded intentional act and that no one can get insurance protection for punching a person in the face because it is clearly an excludable act. Alphonso Williams appealed a judgment granting the motion for summary judgment of defendant ANPAC Louisiana Insurance Company. The trial court dismissed plaintiff's claims against ANPAC, finding the intentional act exclusion in the insurance policy precluded coverage for the injury caused by the insured Christopher Hart. In Alphonso B. Williams v. Christopher L. Hart and ABC Insurance Company, the Louisiana Court of Appeals, Second Circuit, on July 6, 2022, ruled with regard to evidence provided by a video of a battery when Hart punched Williams in the face without hesitation. The facts established in a motion for summary judgment showed that on February 2, 2020, Alphonso Williams and Christopher Hart attended a Super Bowl event at a Holiday Inn hotel in Shreveport, Louisiana. At approximately 7:30 p.m., Hart violently punched Williams in the face, knocking him down. A surveillance camera recorded the incident. At the time of the incident, Hart was insured by a homeowner's policy issued by ANPAC. The insurance policy contains an exclusion of coverage for bodily injury, quote, which is caused intentionally by any insured, even if the resulting injury or damage is different than expected or intended. This exclusion shall not apply to an intentional act arising out of any insured's use of lawful force to protect person or property, close quote. ANPAC denied Williams insurance based on that exclusion. Williams sued for damages against the defendants, Christopher Hart and ANPAC, because in Louisiana they allow an insurance company to be sued just because it insured the defendant. After taking the depositions of Williams and Hart, ANPAC filed a motion for summary judgment, alleging the insurance policy did not provide coverage because plaintiff's injuries were caused by the intentional act of the insured. The trial court granted ANPAC's motion for summary judgment based on the policy language, the video, and the applicable law. The trial court granted summary judgment in favor of ANPAC, dismissing plaintiff's claims against ANPAC, but leaving the claims against its insured. Summary judgment in all courts, and specifically in the courts of Louisiana, must be granted if the motion, memorandum, and supporting documents show there is no genuine issue as to material fact, and that the mover is entitled to judgment as a matter of law. An insurance policy is a contract between the parties and should be construed using the general rules of contract interpretation. ANPAC submitted the surveillance videos to support its position that the insurance policy did not provide coverage because plaintiff's injuries were caused by Hart's intentional act of hitting plaintiff in the face. The video of the incident showed that Hart approached and then punched plaintiff after a brief exchange of words. In their briefs, plaintiff and Hart do not dispute that Hart intentionally hit plaintiff, but assert their deposition testimony creates a genuine issue of material fact as to whether Hart acted in self-defense. Hart testified in his deposition that earlier in the evening plaintiff had bumped into him and verbally insulted him. Hart stated that at the time of the incident he felt afraid of plaintiff, because of his earlier acts at the party and the existing antagonistic relationship between the two of them. The Court of Appeal noted, however, that Hart's subjective belief that force was necessary is only one of the two factors which must be proved to establish a self-defense claim. In asserting self-defense, an actor must show any force used was both reasonable and apparently necessary to prevent an offense against him. A person making a self-defense claim is required to show not only that subjectively the force used was apparently necessary, but also that objectively such force was reasonable under the circumstances. A person who is the aggressor cannot claim the right of self-defense unless he withdraws from the conflict in good faith. In the video, plaintiff is seen standing in the bar area prior to the incident when Hart walks directly up to plaintiff. The video shows they briefly exchange words and Hart then punched plaintiff in the face. ANPAC established by the video that Hart intentionally punched plaintiff after initiating the encounter which caused plaintiff's injuries. Additionally, the video shows plaintiff did not grab or hit Hart before being punched. The Court of Appeal concluded that the video evidence supported a finding that Hart was the aggressor who cannot claim self-defense. Hart's use of force was unreasonable given his initiation of the physical confrontation when he could have kept his distance if actually afraid of plaintiff. Because Hart failed to show that objectively his use of force was reasonable under the circumstances, plaintiff has not demonstrated and did not demonstrate a genuine issue of material fact existed as to whether Hart acted in self-defense. The trial court's judgment was therefore affirmed. Costs of the appeal were assessed 1/2 to appellant Alphonso Williams and 1/2 to appellee Christopher Hart, the two involved in the fight. The insurer was assessed no costs. In my opinion, Mr. Hart was simply unwilling to take responsibility for his wrongful acts. There was no dispute that he hit Williams in the face. The video made clear that Williams did nothing to encourage the beating. The insurance policy clearly and unambiguously excluded intentional acts. The insurer proved the punch thrown by Hart was intentional and excluded. Heck, he admitted it. He admitted that he hit him. He just thought it was protecting himself, which simply did not apply. The parties wasted their time and the court's time trying to get the insurer to pay for the damages caused Mr. Williams. Now Mr. Hart may find he must pay from his own assets whatever judgment Williams will get from the trial court for the battery. This case teaches an assailant must take responsibility for his violent acts and cannot move it to his insurance company. It would be wrong to insure against violent and acts like an unprovoked battery because it would encourage crime. Thank you for your attention.